Hello, I'm Jeff Sheridan. I'm a Minnesota defense lawyer. I practice in the areas of criminal and DWI defense. You know, so much of what goes on in Minnesota's DWI laws happens in the shadows and is designed specifically really to trick drivers into forfeiting important rights they have, that I've decided to do a series of short videos that I've entitled Minnesota's Dirty Little DWI Secrets. I hope you find these videos helpful and informative. Today's video is entitled The Vehicle Forfeiture Trap. Under certain conditions, the car a person is driving at the time of a DWI arrest may be subject to forfeiture to the police department involved in the arrest. That means the state will actually issue a new title to the car, titling it in the name of the arresting officer's department. They can put cherries on the top of the thing, use it as a squad car, sell it at auction, whatever. You have nothing to say about what happens to it. You're just left with the payments. That's the trick. Here's the dirty part. When the officer seizes your car, he hands you a notice titled a Notice of Seizure and Intent to Forfeit. That document tells you that you have 60 days to ask for a judge to review the officer's claim that the vehicle should be forfeited. It then describes the lawsuit that you are required to file within that 60 days. But what the form doesn't say is that if you don't also challenge the revocation of your driver's license in what's called an implied consent hearing, then the challenge to the forfeiture will be useless. It also doesn't tell you that the driver's license challenge has to be filed not within 60 days, but within 30 days. So the person not familiar with how these various actions work together will be lulled into thinking that as long as I get this forfeiture challenge filed in 2 months, I'll be fine, right? And of course, by that time, the vehicle is already the property of the police department. This is a vital piece of information that anyone facing forfeiture must know, and yet, despite the fact that you will walk out of the police station with a whole stack of documents and papers, this information is going to be withheld. Don't fall into this trap. If you've been stopped for a DWI and had your vehicle seized, you do not have 60 days to fight it. You only have 30 days, and you have to know how to serve and file the driver's license and forfeiture lawsuits in that time. Don't delay. Contact my office on the number of the screen for a free in-person consultation with me. There is no obligation, and I can assure you, you will come away from our meeting with a much better understanding of your situation, having lost nothing more than a little bit of your time. Call now or visit our website at www.ssdpa.com.